goes down, forget it, bring him with
Good afternoon. My name is Donna Marie Collins. I'm the hearing examiner that will be presiding over this afternoon's hearing. The request is a variance request, case number VAR 2022-00009. All testimony and evidence that I take in during these hearings are accepted only under oath, so I'll be administering the oath to everyone in the room at one time at the conclusion of my remarks. I am the final decision maker in variance cases. I anticipate releasing a final decision in this case anywhere from 10 days to 2 weeks from today based on my caseload. There's no members of the public here, so I'm going to give an abbreviated presentation. Typically, how we handle this is the applicant, the person seeking the variance, goes first, presents their case, explains why they need the variance and how it complies with the regulations, and then that's followed by the staff person who prepared the staff report. They present their staff report into the record. Normally, when we're dealing with just citizens that are not well-versed in this process, sometimes the staff member will do the bulk of the presentation. I don't know what you've worked out between you, but I'm ready to listen however you proceed with this. If you raise your right hand, please. Do you swear or affirm the testimony and evidence you place into the record will be the truth?
I do.
Okay, thank you. I'm ready to begin.
All right.
We're gonna let him speak. He knows more about this than either of us do.
Okay, very well.
All righty. Turn that on so the remote will work. Excellent. Good morning. For the record, Peter Blackwell, the Lee County zoning section. VAR 2022-00009 is a request by the applicant for relief from LDC section 341174B2A in the MH zoning district, which normally requires a street setback of 25 feet to allow a 0.5 foot setback, yes, half a foot, for an accessory carport on the rear of the property. This is a mobile home residence that was installed or in place around 1983, in the Harvey Heights mobile home subdivision. The residence does meet the normal street setback, and it is a through on both sides because it is a through lot with Spencer Street in front and Candle Drive in back. The lot itself is very small. It's 4,399 square feet. It is the mobile home subdivision Harvey Heights is an 8636 mobile home park. And for the public, in 1986, an ordinance was passed to take mobile home parks that did not meet our zoning code and allow them to become legally non-conforming, essentially grandfathered in, so long as they never changed their layout. And if they did want to change their layout, it would have to be approved by Lee County. So what we have here is one of those lots. The proposed structure on the lot, it keeps getting called carport or garage or shed, depending on when you talk to
I noticed
people.
the site plan referred to it as a shed.
Right. But I can, but the attachment with the specifications is the final document that we want to that will specify the actual nature of the product. The applicant has stated that the intent is to store their car. They want to park it. They're placing it on their driveway in order to facilitate that. They have a rear driveway in existence onto Candle Drive in the back.
Okay, so it's really not a carport. It's a metal building, accessory building,
Right.
primary structure.
Right. Fortunately for us, the 341174 does not make that distinction so that it's applicable whether we call it a carport, shed, or garage.
Okay. Well, I don't want to call it a carport because that's not what it is.
Alrighty then.
I'd rather call it either a metal shed or just a metal building, storage building, and then what they choose to store in it is their business.
Okay.
That'd probably be the best way to word it, metal storage building.
Okay. And the requested structure is 12 foot by 16 foot, 192 square feet total.
And how tall is it?
I believe it's 12 feet tall. Yes. We have the layout, and you can see Candle Drive in back, and the property is at the T intersection of one of the internal roads.
So there's mobile homes, manufactured homes, and traditional single-family residences in this neighborhood?
I believe it's all mobile homes.
Okay.
Right. I know all the abutting properties are. And as you can see, the zoning for the property is mobile home within the park. And on the opposite side of Candle Drive is not part of the mobile home. That's a Candlewood Park subdivision, so it's not subject to the same zoning issues and zoning laws.
What's the primary means of ingress and egress to this lot?
Applicant has said he prefers Candle Drive. The portion of the mobile home that would have served as a carport in the front was enclosed at some time in the past.
So now it's part of the dwelling.
Right. And so they really only have a driveway in front, and he wants to keep his car covered, so he wants to put this in the back on Candle Drive and use Candle Drive as his primary access.
So does the existing driveway extend from one street to the other?
No, there's essentially two driveways, one towards the front, one towards the rear. And the rear driveway does not go all the way back to the house. It stops.
All right, so they're not aligned, in other words.
Right, right, they can't really go through. There's just not enough room between the house, or between the mobile home and the inside property line. All right. So for the review criteria, we use 34 145B3. And I will go through them one by one. The first criterion is that the property does have an inherent exceptional condition, and that is the size of the property. With less than 5,000 square feet, there just really is not enough room to get a whole lot back there. The applicant stated that he really needs to have space between the house and the accessory structure for his for access needs and for lawn care and maintenance and such. And staff concurred that, yeah, it's a very tight property. And it is a through lot, which of course creates that larger street setback in the rear than the normal smaller rear setback, so that adds to the problem. And I just want to note that this property is a lot of record through the 8636 ordinance. Okay. And it was not the applicant that created this problem. It was the platting of the lot at the small size in 1960.
And when did the current property owners acquire this property?
I'm afraid I'm not sure. I can look
About
real
2
quick.
years ago.
Oh, 2 years?
About a year and a half.
In 2000?
You mean
No,
20?
He got it in
2020?
21. He got it in 21.
Okay.
September.
So the structure was already there on the lot?
Right. Now, as far as asking for a minimal possible variance, it seems like a very extreme to go from 25 to 05, but the geography of the situation mitigates that. There's no vacant abutting land that he could put this accessory structure on, and the relief would allow for a reasonable accessory structure, and that's not a huge one. And now, if you notice on this site plan, Candle Drive, the paved portion is actually quite a distance from the rear property line. And this mitigates staff concern that a person coming out of the structure would not have sufficient viewing time before entering traffic. Candle Drive is pretty remote from main drives, and we don't expect it to ever be widened.
The low traffic.
Right. So the main source of concern is really negated by this. And it's not considered injurious to the neighborhood. The existing residence is a reasonable use for the property, and the existing residence is a reasonable size. It's not like they put a gigantic property on there, leaving no room for accessory. So, as far as the lead plan compatibility, the lead plan really does not get down to this level of detail, and as such, it does not. This proposal does not conflict with the lead plan. And in conclusion, due to the above criteria, staff recommends approval of the requested relief for a street setback from 25 feet to 0.5 feet.
Okay, thank you.
Alrighty.
I have a pretty good understanding of what's going on here. What's happened is you purchased a lot in a subdivision that was platted a certain way and did not then comply with subsequently adopted regulations regarding a minimum lot size. So the lot is considered to be grandfathered in, called legally non-conforming, and you can develop the lot, but you have to comply in all other respects to the extent you can. In this case, you're not able to accommodate this shed and meet traditional setbacks and have it work on the property, and that's why you had to ask for a variance. And the county has adopted very strict criteria that has to be met in order to obtain a variance. But because that this lot was created prior to the county's adoption of lot dimension regulations and the recognition of these types of subdivisions actually in the land development code, and the fact that you in no way are responsible for creating the condition that exists on the property, I feel as though it's pretty straightforward that they meet the criteria, and it should not take me very long to prepare my decision in this case. Like I say, 10 days, 2 weeks at the maximum. Okay, is there anything else anyone would like to place into the record?
No, ma'am.
Okay, thank you, Peter. Thank you for coming.
Thank you.
Thank you.